very good afternoon to all of you. First of all, thank you to SCAORA and its office bearers for inviting me. It's good to be in the Supreme Court. First time after my retirement, which was the first virtual retirement, so it's good to be back. See, when you work somewhere for 42 years in an institution, whether to the High Court, so you have a close association. So when I was asked that day at the Law Day function, I felt interested to take up the challenge of speaking to lawyers. It was a pleasure. The office bearers have been kind enough to send me a couple of the old question papers, because I will be speaking on drafting basically. Let me tell you a secret that drafting is, I've always been passionate about drafting. And in fact, when I was offered the senior gown in Simla, I refused it because I told the Chief Justice, Justice Raju was the Chief Justice, that I don't want to give a draft. I was senior in one draft. So that was the main reason, it was in writing directly. There is a drafting as far as this paper is concerned. From the two papers I've examined, you get about half an hour to read it. Please spend not only half an hour, if need be, spend 40-45 minutes reading it. Because the answers all lie in the questions themselves. I mean, rest is your knowledge of law and all. I'm not speaking about that today. It's the drafting which I'm talking about. The entire drafting is on the basis of a couple of paragraphs which are given to you. Maybe 2 paragraphs, 3 paragraphs. And I'd asked my law clerk to, I'd kept back a photostat copy of a SLP with me as a reminder of how badly drafted things can be. But since when I went through the questions, I found that almost all questions say there's no list of dates required. But to what I had kept was a 5 or 6 page writ petition in the High Court on a matter of education of admission to college, dismissed by a 2 paragraph order by the High Court. And the list of dates ran into ZZ and beyond. Now, how those facts were brought in, I don't know. Because it started right, actually, I'm not joking, it started from the date of birth of the guy, which was neither relevant nor on the record of the High Court. So you must stick to what are the facts. Please don't give any facts which are not there. You have to really be concise. And then be clear about what you are drafting. If somebody would like to draft a criminal appeal or a bail petition, somebody might find it easier to do a civil suit, but civil suits are not easy, I can tell you, unless you have practiced in the trial courts or courts which have original side jurisdiction. If you only practice in the High Court, Supreme Court, you'll find it very difficult to draft a civil suit. So don't attempt it unless you're very, very certain you can about how to draft a civil suit. So then you must not only be aware about the Supreme Court rules and orders with drafting of a civil suit, but also the essentials of a civil suit. One of the suits I was going through were related to a specific performance of an agreement between 2 states. Now, in a specific suit for specific performance, there are certain essentials which have to be completed and proved. At the Supreme Court level, if you've not done much civil work, you may not find those, and those you will not find in the rules of the Supreme Court also. That you're always ready and willing to perform your part of the contract. These are basic things, but you may find your suit to be totally, without a cause of action, basically, if you don't create these things. So, stick to what you know. And don't try something which is very different to what you have done. Unless you're certain, if you're certain, please do it. The second thing is to be concise. And that I will say not only for this paper, even when you draft SLPs, after you become OORs, I wish you all the best and many of you should become AORs. Please don't lend your name as AORs, but become true AORs. And when you draft, see, every judge has to go through about 50-60 files on a Monday or Friday. Now I think something has changed and there are some 10-12 files, transfers and all, but those we hardly read. I mean, let me be honest, we rarely read those files. The law clerks will put up a small note and that's. Bail application something we go through. Most often I won't go through, but transfer petitions even I never went through it. Unless the law clerk said that this has some difficult issue in it and they need it. But in a regular SLP, which I would go through thoroughly, you get a minute in court, or maybe half. That is if you're lucky, if you're before a judge who's willing to listen. Others have made up their mind and don't even want to change. So your petition should be drafted in such a way that you grab the attention of the judge in the synopsis. And most of these questions will ask you to prepare a synopsis. And that synopsis has to be what I think is a subject which should be taught in every law college, is Pressy writing. How to bring out the gist of the matter in a paragraph or two in such a manner that you draw the attention of the judge and he says, yes, there is something worthwhile in this. And that will help in the question paper also. Because if you can really, in a few words, sum up what is the case, because that's the first thing we go through is the synopsis or the list of things. And if you can grab the attention of the judge, there you succeeded. Then your language should be simple. See, for most of us, English is not our mother tongue. We don't think in English. We think in Hindi or the regional language which we've grown up in. And then we translate it in our mind and then put it in words. तो वो जो सारांश निकालना है, वो आपको हिंदी में ही निकालना पड़ेगा, or whatever is your local language, and then put it in English. So don't try to use very flowery language. Use very simple, basic language. Short sentences. If a sentence runs into a para, and that para runs into 2-3 pages, then you like one of the judges from my high court whose many judgments have been set aside on the ground that they're not understandable. I mean, the gentleman has had at least 5 or 6 judgments set aside on this floor. Because jitna lamba sentence hoga, if your sentence runs into half a page or 2 pages, there will be confusion. If you use short sentences, simple short sentences, they are the best. I'm a great follower of Lord Denning when it comes to his judgments. Not only in his philosophy of the law, but also in the manner he wrote judgments. Though I have great respect for Justice Krishna Iyer, I didn't ever like the way he wrote judgments. Because the judgment should not be written in a manner that you have to take out a dictionary to understand what the judgment says. Similarly, when you draft a petition, it should be crystal clear what you are intending to do. And if that is clear, that is how you get the attention of the judge. You may not win, you are not likely to win all cases. Many of your SLPs are going to be rejected. But the way of drafting is that within that one paragraph or 1.5-2 paragraphs, you should be able to convey what is the deal. And I think 95% of cases, In 95% of the cases, you can do it in that much time. Here, the facts are never running into more than 2, 3, 4 pages. Now, if you answer a question like there's this one question which is a long agreement, now you have to mentally decide what are the crucial aspects of that long document. And what is the controversy? Because the entire document has been given to you, but what has been decided by the High Court or what you have been told has been decided by the High Court is only a small matter out of those. So you have to identify and then highlight those only. And there are others where the question only runs into a paragraph or in a page or two to make a short 2 paragraphs out of that shouldn't take much. The other thing, the next thing will be to have clarity on what is the provision of law which is applicable in the present. Sometimes the provision of law is given in the question itself. Sometimes for common things which all lawyers are expected to know, CRPC, CPC, etc., they are not given in the question paper. So what you are expected to do is to have total clarity of the law and then draft. Once you have decided, some of the petitions, they have purposely give you some cases which are lost cases. I mean, reading from the 2 question papers, I can make out that it's very difficult to draft those petitions also, because they are almost lost cases. But that's where the ingenuity of a good draftsman comes into play. That even with those limited facts and that position of law which is against you, you somehow draft a question which becomes a substantial question of law. Drawing from my experience, you see, in a state like Himachal where I was working, you couldn't work on one side, you couldn't be a writ lawyer or something, you were a jack of all trades. And the most difficult thing, one of the most difficult things I ever found to do was to draft substantial questions of law in a regular second. See, saying is the judgment of the High Court against law is not a substantial question. So when you frame that substantial question of law, you must frame it. If the minute you say whether in the facts and circumstances of the case, the question is not a question of law, because you yourself bringing in facts and circumstances. The question of law will have to be based on the section concerned, on the legal proposition, and there you will have to, because some of the questions do ask you to frame the points of law arising. The points of law should be legal points and not points of fact. And I would request you that when you draft these SLPs, don't include matters which are totally irrelevant, like I found checking 1 or 2 papers when I was here, he is very poor. I mean, where do you get that? So you can't get mercy from the Supreme Court judges, even in good cases. How will you get it by just saying that the man is poor? You must realize that and this is a very, very difficult paper. I don't know what Mr. Arora will tell me. I don't know what is the pass percentage in a drafting paper. I think it's much easier to pass a paper on a subject. Yes, because either you know the subject or you don't know the subject. And if you know, drafting is a skill which is very, very different. It's a skill which you have to practice day in and day out. Like as I said, I followed Lord Denning. If you go through any of his books, especially there's a judgment which I always used to say, I forgot the citation, probably it's 1984 ACJ, Croak a minor versus somebody. It's a motor accident, it's a accident, it's a negligence claim. I think in the first paragraph, there are 10 sentences, not one sentence runs over 6 or 7 words. It says Croak was a miner. He was bright as a button. Then he met with an accident. He became like a vegetable. See, it's very simple to understand what it is. See, if that is your approach, the judge understands. Or in this case, the examiner, who probably will be a judge or a senior counsel aspiring to be a judge. So, they will understand what you are trying to convey. Because what is the idea? The idea is to convey what you have to say. I am not here to lecture on the legalese, on what is, because every question may have a different legal knowledge of different legal, different statutes or different aspects of law. But here we are concerned only with drafting, and by and large I found that most of the questions themselves, half the answers are in the questions also. So pick them out, spend a lot of time reading. I mean, I can't emphasize that rereading of the question enough. Because unless you're very clear what the question is, you will not be able to successfully answer. And that is why this paper gives you half an hour to read the questions alone. The other thing is to attempt only those questions which you are sure about the law. You can't go on guesswork as far as law is concerned. And if you do these things, I find no difficulty in your attempting the paper and doing well in the same. You'll have to have, all of you have experience of the Supreme Court, all of you are bright, you have done matters, you have practiced at least 4 years, some of you much more than 4 years. So you know how things work in the Supreme Court. But when it comes to the questions, they are very less. They can be from drafting a civil suit to a mundane bail application or a transfer. See, transfer application, or I can still understand you writing something which is not, because a poor lady's transfer application, there will be something which may transcend the facts a little bit. But other than that, you have to stick to the facts and facts. List of dates, I have all the 2 papers you sent me, there's no list of dates ever asked.
No, normally not, because
that will be an exercise.
The SLP formats or something, synopsis is very important.
Synopsis is the,
Formulating
actually
your
the
questions
synopsis is the, even in the question paper, synopsis will be the biggest. And after that, you see, when you draft the SLP portion, then give all the facts which are given in the question. On one side I have said be very, very concise. On the other I am saying don't be verbose, but no fact, no relevant fact in fact, which is part of the question, should be left out from drafting of the SLP or the bail application or whatever. The other thing I am not very clear about, I wanted to ask, but I missed. Are you supposed to draft decrees and orders?
No.
So why does the syllabus say decrees and orders and writs?
Orders.
Normally,
That's why I was a bit confused. Why should, for an AOR examination, you be asked to...
No, it's normally transfer petitions, SLP, criminal and
No,
civil.
I've got 2 papers.
Previously used
kind
to be
of-
different, yes. And then you do have transfer petitions, you can have appeals. Appeals are very different, writs.
Yes,
Writs.
see, now,
And suits, but suits.
see, for a suit, pleading the cause of action is essential in a suit.
Yes.
Not only the facts, what is the cause of action, the limitation, the court fees. All these are very, which are part of the CPC, they'll have to be pleaded. You can't draft a civil suit without these essential paragraphs. When it comes to SLPs, etc., there are some which you all know, there's no other similar SLP. I'm not going to those things because you know all that. But when you come to the special leave petition part of it, I mean, dealing with SLPs, after the synopsis, they give a complete set of the facts as set out in the question paper. And weave it in a way that it is chronological, sequential, and not that it is, jumping from one to the other. See, sometimes what happens is when it's drafting, even though it's a good point, the good point gets lost because something which is not so good is said. Always now start as a lawyer. Always start with your best points. Though some judges will not agree with your best point or may agree with your best points, but always try and start with what you feel is the best. When you draft an appeal, now you have a lot of statutory appeals in the Supreme Court. Now, supposing you have to draft a statutory appeal in the Supreme Court, you will have to give the provision under which the appeal lies. See, supposing they say file an appeal against X order of such and such tribunal which lies to the Supreme Court, then you'll have to give the section under which the appeal lies. Without that, you're losing out on marks. Now, if the appellate provision can be varied, so if you don't know the appellate provision, you're already at a loss. The appeal provision may provide that the appeal lies on a substantial question of law. There are certain appeals which lie on facts also to the Supreme Court. What is the jurisdiction of the Supreme Court? So that you have to draft your case accordingly, that this is a case where this is what you judge. Then we come to, let's say, transfer petition. As young AORs, many of you only would get transfer petitions and bail applications in the beginning. That's how life works. None of us started off with big cases in the beginning. So, even for this exam, that is going to be a run-of-the-mill practice. So please see because this also changes from time to time. The Supreme Court's view also changes from time to time. What is the view at that given time? And what is the essentials of a transfer petition? By and large, you will have transfers from one state to another. In most cases, there will be matrimonial transfer, which will be very easy to draft. But if there are something which is not matrimonial, and for something, say, hardship or some other thing, then you'll have to plead, because then you must know the provisions relating to transfer, why transfer is allowed. See, just drafting is not sufficient. You must know whether it is coming under CPC or under your
Constitution.
That how can a case be transferred from one state to the other? See, matrimonial cases have become very easy because it's a matter of practice and we transfer that.
Standard for almost. But
maybe in the question paper you will not get something like a matrimonial petition. And that is where you will be in trouble, and if you draft it like a matrimonial transfer. Bail applications. You must be clear whether the facts indicate a previous bail application or not. If there is even the slightest hint of a previous bail application, then that please mention that there was a previous bail application and it was decided one way or the other. Then you can make out a case why that is not applicable, why it doesn't bar a second bail application. But the minute you hide it, the examiner is going to be very tough. The other thing is Article 32 petitions. Please read Article 32. See if the facts actually, if you're told to draft an Article 32 petition, you will have to draft it for the consideration of the examiner. But then please draft it in a manner that it falls within the purview of Article 32. An invasion of the fundamental rights of a citizen. Everything doesn't come under Article 32. And that is going to be a big problem. Contempt petitions. The clarity of the order. Supposing there could be two situations in a contempt. Either somebody's contempt petition has been dismissed by the court below, or it's a contempt petition in the Supreme Court of a Supreme. The order, what does it say? Is the final portion of the order the declaratory part of the order, of which contempt, or unless it's a criminal contempt, of that's of a different nature. So section 12 and 15 of the Contempt of Court Act, you must know thoroughly before you can even draft whether it is a civil contempt, whether it's a criminal contempt, whether the contempt petition lies straight to the Supreme Court, or whether you have to seek permission of the Attorney General before filing it. So these are things, and if you have not sought that permission, then either you say, because those things may not be there in the question. So that is where your ingenuity will lie in introducing things that say, yes, I had applied, but rejected on this ground, and therefore I'm coming on this ground. Interlocutory orders and miscellaneous acts. Very little attention is paid in real life, as also in these papers. I hardly found any question on an interlocutory application. But if there is, see, you must know, especially if you have an interlocutory application for stay, what are the principles for grant of stay? What is the urgency? Balance of convenience? Some rights which cannot be rectified after some time. All these factors will have to be considered. But coming back to square one, all I will say is that please be simple, straightforward, and there should be clarity in your answers. And then you will succeed. Wish you all the best. Thank you. Have a very good day.
Thank you very much, sir. That was a very inspiring lecture with a lot of clarity and very comprehensive. It covered the entire subject of drafting. Now, I would request Madam Meenakshi Arora to give her lecture. She was AOR since the year 1989 and she got designated in 2013. So you can understand that she had a practice of 14 years as an AOR, and she was a leading AOR because she was an AOR when we joined the profession. So, Madam Meenakshi, she has to go because her matter might come sometime. So,
That's okay. I will
but
try my
we have
best
requested
to
her.
give
So,
you some.
ma'am, you can start now.
Good afternoon, Mr. Deepak Gupta. It's good to have you here. As I feel you feel coming back, we also like having you here back. That miss us. And good afternoon to all of you, and thank you for taking your time out for this talk that we are doing today. You have already heard from Justice Gupta the finer nuances of your drafting paper. The practice and procedure is also very intricately linked with your drafting paper. So it's very important that you prepare your practice and procedure, because as it was just said a few minutes back, that what is the provision under which you are filing your case? So unless and until you do not know the contents of that, or you do not understand the final nuance of that, you will probably also go orally into your drafting. So because of this time, I would have loved to spend much more time with you on this. I've done this, checked these papers in the past, and I've also done a few rounds of this lecture. But today may be a little difficult. Be that as it may, let's just get into it head on. Because you intend to take an AOR exam and you wish to practice in this Supreme Court of India, the first thing that you must concentrate is what are the various jurisdictions of this court. So, you have the appellate jurisdiction, you have the original jurisdiction, and you have the advisory jurisdiction. So first you divide your jurisdiction into that line for this court. Now, appeals. under the Constitution as well as from the statutes are from various categories. Now, it's important for you to understand, because if you get a question that what are the various jurisdictions of the Supreme Court, while you must be concise, but you must understand and you'll be able to put it in one line, and that should be more than enough for you to get through, provided you've got it right. So when you take the appellate jurisdiction, just come down to, first of all, the appeals provisions which are provided in the Constitution itself. The first of all, Article 132 of the Constitution, where a High Court certifies that a case involves a substantial question of law as to interpretation of the Constitution. So understand what is Article 132 if you're coming in an appeal. High Court has certified that it's a substantial question regarding interpretation of the Constitution. Then if you went into Article 133, substantial question of law of general importance, and that is what is needed to be decided by the Supreme Court. That's how the High Court will certify it. Now these are two entirely things. The first part is constitutional, other is of a substantial question of law. So that's the nuance that, when you look at the answers that come before you, you are looking whether the person has got the distinction, the fine lines between these provisions, and understood what they really require. Then of course, you come down to article, now this is again important, because if you have an examiner who used to be as tough as I used to be, he might look out for it. Which is to say, Article 134. And if you put it in a contrajunction with something like Section 379 of CRPC, they both are very similarly worded, but there is a marked distinction. So you need to understand these jurisdictions. I cannot go into all the details given the short frame that I have here, but I'll just give you some flavor and idea, and the rest you will perhaps, when you will read them closely enough to understand where the distinctions lie. Very, very simply put, under Article 134, when you will file an appeal to the Supreme Court, what will it arise out of? It will be an appeal where the High Court may have reversed an order of acquittal and sentenced a person to death, or it withdrew the trial from the trial court towards it and convicted the accused and sentenced to death. Now, death is very different distinction which will happen with the CRPC provision. Or it certifies it's a fit case for an appeal to the Supreme Court. Now, when you will see at the same time Section 379 in CRPC, the first part of it is very similarly worded. High Court has reversed the acquittal, sentenced to death or to life imprisonment or for a period not less than 10 years. So, if yours was a case, let me say, of a life imprisonment or for that of 10 years, it's a reversal again from an acquittal to a conviction by the High Court. You will go under 379. But if it was a death sentence, you had your remedy under the Constitution, under Article 134, at the same time had a remedy under the CRP provision, not for 379. Now, this is where I'm trying to draw your attention to understand these finer nuances, and if you will be able to put it into your answer, believe me, you will score much more than perhaps somebody who will not realize this final thing. And as when we prepare the questions, and I'm sure my colleagues this year, when they prepare the questions, they also keep in mind these little things, and when they check your answers, they look out whether you have found that, and they give you the added marks. You may have the normal marks, but these little things add to your marks, and if there is a question to that extent. Now, SLP you all know, but do not forget, an SLP would lie against any judgment, decree, determination, order of a court, any court, mind you, it is court, the word used is court, or a tribunal, but it is discretionary. So remember always that. Now, under the appellate jurisdiction of the Supreme Court, you will find appeals provided in various statutes, and I'm only just going to very broadly say that, but please read that for yourself. You will have an appeal provided under the Customs Act. which can come straight from the tribunal to the Supreme Court. The issue is classification, valuation. If the issue that arises from a tribunal's order deals with classification of a product or a valuation of a product that is for the purpose of assessment, appeal lies straight away to the Supreme Court, and you don't have any other remedy. In other matters, there are some appeals which lie to the high courts also, but this is where it lies. Similarly, you will have it in the excise. Now you have the GST, so again the same provision. Consumer Protection Act, you have an appeal from NCDRC to the Supreme Court. Contempt of Court Acts, you have an appeal here. You have it under the Competition Act and various other statutes. So please do read up that part where you have direct appeals to this court. Now that is broadly your appellate jurisdiction of the Supreme Court. Come down to the original jurisdictions. You have Article 32, as Justice Gupta just pointed out. Only remember when you are dealing with Article 32 on a couple of things. Please, as he said, and which you need for your drafting, is to understand what is the nature of the writ that you are seeking for. Habeas corpus, mandamus, prohibition, quo warranto, certiorari. Understand that, and please remember those particular and how you're going to formulate your prayers, because the prayers are another thing that we look at when we look at your drafting when it comes to a writ. The other thing is 32 can only confine itself to the fundamental rights and no other right. It is not going to deal with the constitutional right. That's all 226. Powers of the High Court are much wider. Supreme Court will confine itself to a relief which must flow only from the chapter of fundamental rights and no more for that matter. The next original jurisdiction is the original suits. As you said so, this thing, Supreme Court unfortunately has very few original suits because that jurisdiction is quite limited. At one time, I do believe that Supreme Court did have a pecuniary jurisdiction or other, but the amount was very large in those days and then it was done away with. Today, it is a dispute with the Government of India in one side and one or more states against another state, or between Government of India and any other state, or between any two states or more. But that's where all the original jurisdiction in terms of a suit is limited so far as the Supreme Court is concerned. The other original jurisdiction is your transfer cases, transfer petitions. Now remember, your transfer petitions are not all Section 25 petitions of CPC, which are the matrimonial matters, as Justice Gupta just pointed out. You have a very important provision in the Constitution, Article 139A1 and A2. There is a distinction between the two. Please read that up. Now, so far as A1 is concerned, where issues involving the same or substantially same questions of law are pending before Supreme Court, one or more high courts, or maybe 2, 4, 5 high courts across the country, and if the Supreme Court is satisfied, it can on its own motion or application by an AG or by any party transfer these cases all either to itself if there is a case pending here, or to one of the high courts where the multiple of these cases are pending, or it can withdraw from all the high courts and transfer it to itself. So that's 139A. Now, just as Justice Gupta pointed out, in transfer cases, there's one thing that you must learn to draft is draft a certificate. Whenever a petition is asked for under 139A, you have to draft a certificate certifying that yes, these cases are same or similar, pending between different courts in the country or pending in the Supreme Court and in the different courts. So that certificate is something that we look at how you have drafted, and that's an integral part of a transfer petition under 139A. Remember to draft those 3 lines, even if you don't have the time to complete it, they're the ones that will get you the marks. Now, 139A2 is where the Supreme Court exercises something similar to Section 25 or the CRPC provision. Supreme Court, if it deems expedient to do so for the ends of justice, transfer any case appeal proceeding in any of the high courts to itself. So the court transfers it suo motu to itself. But the words that are used in 25, but this is suo motu, in 25 any of you will bring it on the CPC. The same provision goes for 406 of CRPC. Then the other important original jurisdiction is the election disputes. So remember, where there is a doubt on the challenge to an election of the president or the vice president, only those two petition categories come to the Supreme Court, and which is Article 71 of the Constitution. So those are your original jurisdictions which the Supreme Court exercises. Now, remember your advisory jurisdictions that Supreme Court exercises. One is Article 143(1), where a president may feel that there is a question of law which is important to obtain the opinion of the Supreme Court. He may make a reference. Those are the reference cases to the Supreme Court, asking for an opinion of the Supreme Court. Now, you have a similar provision under Article 317, which is regarding removal of an officer of a public service commission. Then you have something to do with the appointments under the Competition Act. These are all jurisdictions which are the advisory jurisdictions of the Supreme Court. My team is telling me that you have to go there, your matter is reaching, but I think I still have a little time, and I am going to complete this chapter, and I'm going to give you a few little bits on the contempt as well as on the review and curative, and then I will only rush for that. Now, in reference matters, please look up the jurisdiction under the Income Tax Act. We used to have the previous, today you have under the Competition Act, Right to Information Act, etc. Those are the acts that you must look up because there are provisions for making references to the Supreme Court. Then come down to the review jurisdiction of the Supreme Court. Now, remember, a review has to be filed within 30 days of the order. And there are no oral arguments in a review. It goes by circulation. The matter has been challenged before the Supreme Court that why there should be no oral arguments, but the Supreme Court has authoritatively settled that the reviews can go by circulation and there will be no hearing unless the court deems it fit to issue notice and to invite the parties for an oral hearing. So the last, while the review jurisdiction comes under Article 137 and is again a constitutional remedy, the jurisdiction that the Supreme Court developed itself was the curative. And there is no writ that lies against a judgment of the Supreme Court passed. Okay, so now I am very, very sorry. I really wanted to do this longer with you guys, but the curative is something that you must read up, Hurrah versus Hurrah, because there is no writ against a judgment of the Supreme Court. The Supreme Court has devised a remedy. You can file a review petition. You will take your grounds in a review, and if your review is dismissed, you can file a curative. But having said that, it's not like in every matter you will have the right to file a curative. Curative remedy is extremely limited. Apart from the fact that it will need a certificate both of a senior counsel advocate as well as that of an AOR, senior advocate to certify that the curative is actually maintainable within those two parameters which the Supreme Court has laid down, the AOR to certify that the review had been filed and the questions that have been made now in the curative are arising in those particular review petitions. So do remember that those two certificates are a part of a curative. Apart from that, where will a curative lie? Only and only if you are able to show that there was a violation of principles of natural justice, that you were not a party to those particular proceedings, and the judgment that has now come affects your right materially. So, violation of natural justice. Or the proceedings have proceeded where you have not been served with a notice and you could not participate. So, one ground on which a curative is maintainable is on the principles of natural justice, and the second ground which the court has held that you can file a curative and it will be maintainable, is if the judge has failed to disclose his connection with the subject matter of your dispute, or that has given apprehension in the minds of the parties that perhaps there was some bias or they have been unfairly treated. So it's very, very limited scope in a curative. We all tend to advise file a curative, file a curative. I, for myself, in my entire career have given 2 certificates because you really can't give one. You know, the cases just don't fit into it. Now, having taken you through this very broad scheme, I want to just, touch with you very, very briefly. You know, on the curatives, I will really advise you to look up these few judgments. You may just make a note. You must read Hurra versus Hurra. And then, after that, you have the Yaqub Abdul Razak Menon, which came in respect of the criminal matters, the sentencing. So there they said we will hear the curative in the court. So that's a very important one. Please read that. Then they have here said that here curative is maintainable by a complainant. Now, assuming a complainant was not before the court, but a complainant can file a curative. So who has the locus to file a curative? Please look up National Commission for Women versus Bhaskar Lal Sharma. And then you have that Indian Council for Enviro Legal Action versus Union of India. So these few judgments you must look up for the purpose of understanding how the curative works. Now, so far as the review is concerned, I would advise you to closely look at Article 137 and please read that with the provisions of Order 47, Rule 1 of the CPC, because Supreme Court in its judgment has very categorically laid down that principles which apply under Order 47, Rule 1 apply also to the reviews under Article 137 CPC. So the important judgments, there is a series of judgments that I had done, but I will advise you to read one particular judgment which is very important, will put your fundamentals in place and easy to answer if you have a question on a review petition, which is Kamlesh Verma versus Mayawati. It's a judgment of 2013, if I'm not mistaken. Please read that judgment of Justice Satasivam. He has very categorically said, here a review is maintainable on these 3 grounds: error apparent on the face of the record, or you have not been able to produce a document which you could not have produced at that time, or there are sufficient reasons to do so. But at the same time, he set out about 8 or 9 instances where you cannot file a review. So you have an understanding where a review is not maintainable. You know, I will take your leave today at this point. I wish I had spent some more time with you, but I think I have given you some broad idea on your practice and procedure. So if you spend a little time on it, maybe it might help you. Thank you very much.